I hope that all of you are prepared for the lesson. Now, what are the topics that you are discussing currently? Yes, can anyone tell me quickly?
Legal capacity, sir.
Legal capacity, very good. Yes, so up to where did we reach in our discussion on legal capacity?
Rights to execution.
Quick.
Rights of execution, sir.
Pardon?
Rights of execution.
Hah? Dah.
Yes, quickly. Is Madam Alifa Noor Shukriya here? No. Madam Siti Noor Atika? Can you tell me where we stopped? Siti Noor Atika? Madam Aifi Shafira Elia? Is she here? Yes. Mr. Muhammad Amzar? Can you tell me where we stopped? This is a flipped class, which means you should prepare beforehand. And we are just going through the basic aspects of the topic. Mr. Muhammad Shukur Hakim, are you here? No one? None of these are here? There are 84 people here. Mr. Muhammad Shukur Hakim. Well, all of these, if they want the attendance to be counted before we end the class, they should let me know that they are here. All of those whose names I called now, let me know before the end of the class that you are here. Let me know means tell me. Mr. Muhammad Hazim.
Yes, sir.
Yes. Where did we stop?
We stop at Ahliyatul Ada, capacity of execution.
Okay. Which part? Did we complete the discussion?
Sorry?
Did we complete the discussion?
Well, from my notes, I don't think so.
So tell me where we stopped.
Where we stop?
What have you taken last? I asked you to write down everything. Quick. Yes.
So I think it's detrimental property wise.
Pardon? Quickly.
Detrimental property, sir.
What do you mean? Okay, you are somewhere. That means you did not go through or revise. If not, you can answer with some understanding. Perhaps you are correct. Yes, we had talked about Ahliyatul Wujub, or the capacity of assuming first, which is possessed by every human being, which only gives rights to, or which only results in the entitlement to ownership, as well as entitlement to rights gained through contracts. And by rights here we mean the rights related to property. You see, so these are the features, main implications of, or outcomes of the capacity of assuming. Then we talked about the capacity of execution of Ahliyatul Ada, which we said starts in an incomplete form, along with the person's intelligence reaching a level which is recognized in Sharia. When does this happen? This happens when the person reaches the age of 7 lunar years without an impairment or defect to his intelligence. So we call this tamiz, or age of discernment. So at this point, the capacity of execution starts in an incomplete form. So his actions and utterances, which that is tasarrufat, start to become recognized partially, which means not all his utterances are recognized and not all his actions are recognized. Some are recognized based on the limited level of intelligence found upon discernment. So we said that there are some religious implications: belief recognized, worship recognized, and as far as property issues are concerned, now in some schools of Islamic law, such as the Hanafi school and to some extent the Maliki school, certain contracts can be created, transactions can be created. So here we started to talk about purely beneficial transactions and purely detrimental transactions, and transactions that could result in either gain or loss, benefit or detriment. So I think we talked about the first two. The third type, which refers to transactions that may result in gain or loss property-wise. Now these are contracts such as sale, investment, partnership, you see. So can a child or a person who has the capacity of incomplete capacity of execution, ahliyatul ada and naqisa, can a person create these transactions? In the two schools we mentioned, he may create, but these contracts will only become valid and result in legal effect only when his guardian permits, with the approval of his guardian, either before he creates this contract or after he creates this transaction. The guardian should endorse them. At that point, the contract will become valid and effective, and or he has to, the person himself would obtain complete capacity of execution at a later point in his life. Then he himself can endorse, and at that point the contract will become valid. Well, so remember, by investment we mean investment along Islamic lines, which may result in gain or loss. It is not, by investment we don't mean lending on interest, where interest keeps accruing. You see, we mean investment in through means where gain and loss both are possible. So the details are as I mentioned to you. Well, now then comes complete capacity of assuming. Complete capacity of assuming, where the person's utterances and actions start to be recognized. So this is the eligibility of the person for the recognition of his actions and utterances. Now, under complete capacity of execution, his intelligence is recognized in Sharia. Therefore, what he does and what he says has weight, recognized in Sharia. You see? So what he says, what he does will have implications, outcomes, repercussions. You see? So the eligibility of the person for the recognition of his utterances and actions, this is complete capacity of execution. So as we said, the capacity of execution depends on intelligence. So this capacity is attained once the person reaches adulthood with intelligence. With intelligence, we mean by with intelligence, there being no impairment or defect in his intelligence. He reaches adulthood with a normal level of intelligence without his intellect being affected. Well, so remember that it is not neither this nor the incomplete capacity of execution are the outcomes of age alone. The basis here is intelligence. Well, so once the person obtains the complete capacity of execution, now his utterances and actions have weight. So if he does any mistake, now he is liable to punishment. Now he is criminally liable. You see, his actions, utterances start to be recognized. So his actions and utterances have weight. So they will have their implications and repercussions. So this is the point at which the person becomes a mukallaf in Islamic law. Mukallaf means a person who is addressed by law. Now he becomes a person addressed by the Sharia. The Sharia now applies to him with all the details of the Sharia, all the rules of the Sharia apply to him. So it is his responsibility to abide by the Sharia and not to violate it, because now he is fully addressed by the Sharia and has become an addressee of the Sharia, which we call by taklif and becoming a mukallaf. Well, now the period preceding this, the period preceding attaining complete capacity of execution, is the period for preparing for taklif. Preparing for taklif. He is going to be addressed by the Sharia once he becomes an adult with intelligence. So the period before is for preparation. And the parties to whom preparing the person for taklif is assigned are the parents. Parents are enjoined to prepare their child, prepare their ward or the person under his care for taklif by giving him the necessary knowledge and awareness and a sense of importance of fulfilling the commands of Sharia. So at this point, now he is obliged with the 6 points of belief of Islam and the 5 points of obligations, as well as all other rules of the Sharia. Well, and now he is criminally liable, and as we said, his actions will have repercussions, and if he violates the Sharia, they will be punishable. Well, now as far as creating contracts is concerned, creating contracts with regard to those contracts which involve property related contracts, in some schools of Islamic law, such as the Shafi'i school, creating property related contracts still requires one more ingredient. Having complete capacity of execution alone is not sufficient. In the Shafi'i school, another ingredient is required, which is called rushd. Which is called rushd. Rushd can be translated as prudence. You may come across other words. This refers to the good sense related to property matters as well as religious matters. Having good sense and sound judgment with regard to property matters as well as religious matters, which principally means that a person has an idea of the value of property, that is not prone to waste away property due to having no sense of the value of property. This we shall discuss under an impediment called saf later, imprudence. So by rushd we mean lack of imprudence or lack of saf. So you should not be suffering from the impediment that is called suffer or imprudence. It should be Rashid, or person having rushd or prudence, and should have a value of the sense of property, and the guardian should verify whether he has rushd or not by enabling him to create small contracts to see whether he can manage his property wisely, he does not waste away his property on what is not beneficial, as well, and by good sense in religious matters, what is meant is that he should not be using his property and wasting his property in unlawful avenues such as gambling. You see? So Until the signs of rushd are evident, the guardian will continue to have control over his property. He shall not be allowed to manage his property himself. So the guardian will create contracts pertaining to property on his behalf. So remember that rushd is required, you see, in addition to complete capacity of execution, for creating property related contracts only. Other contracts such as marriage, these do not require rushd. The person who has the complete capacity of execution can himself create such contracts. Now, in the Hanafi school of Islamic law, rushd is not really a prerequisite for creating property contracts. Still, the guardian will continue to exercise his control over the person who attained complete capacity of execution but who does not have rushd yet, as a precaution for the purpose of safeguarding his property. Although he has the right to create contracts, his property will not be entrusted to this person who does not have rushd. But when he reaches the age of 25 in the Hanafi school, irrespective of whether he has rushd or not, as long as he has intelligence and complete capacity of execution, his property will be entrusted to him. So if he wastes his property away after that, that is his problem, and it will not prevent him from having control of his property. Well, so we shall look at this again under the impediment of imprudence or saf. Well, so this was a very brief discussion of legal capacity. So you must have sufficient knowledge of the nature of each of these types and the implications. So we talked about 4 stages: the fetal stage, and then infancy, before the age of discernment. So here a person has the capacity of assuming only, and if he obtains discernment and he reaches the age of a discernment with a sufficient level of intelligence, then he will have incomplete capacity of execution, where he will be able to create some contracts, especially in the Hanafi school. But remember, he is still not criminally liable. He has no obligations as such. So violation of Sharia does not apply to him. He cannot violate because his intelligence is not fully recognized. But his actions, good actions, will be rewarded. And once he reaches adulthood, then he will obtain complete capacity of execution. His actions and utterances will become recognized, and he will become criminally liable, and is capable of creating transactions and contracts. But for creating property-related contracts, schools such as the Shafi school require an additional ingredient called rushd. So rushd is not a prerequisite for complete capacity of execution. It is something in addition to the complete capacity of execution for creating property contracts only. Well, so now we shall go to discuss impediments to legal capacity. Impediments to legal capacity. By impediments, we mean those factors which can remove, diminish, or alter legal capacity. We talked about the types of legal capacity, but certain factors can have the effect of removing legal capacity, or reducing legal capacity, or converting it into some other capacity. So when we say the capacity is removed or reduced, we are talking of which capacity? Are we talking of capacity of assuming or capacity of execution? Ahliyatul wujub, ahliyatul ada, who can tell me? When we say that the factors, some factors can even remove the legal capacity, which exact type are we talking about? Is it capacity of assuming or capacity of execution?
Capacity of execution, sir.
Very good. Why? Because capacity of assuming is never removed. I think we said repeatedly that every human being from birth to death has the capacity of assuming, it never goes away. Everyone always has this capacity, and if he has this capacity and nothing else, the features of this capacity will be with him throughout his life. If he has the necessary level of intelligence, he will get the capacity of execution either in the incomplete form or the complete form, in addition to the capacity of assuming. The features of capacity of assuming are separate, they are with every person. In addition, if based on his having intelligence, he will obtain the capacity of execution with its resultant features. So these impediments can affect the capacity of execution and not the capacity of assuming. Well, so we shall talk about some of these very briefly, such as insanity. Well, this list is, which you can see on the screen here, is something I prepared for some other class. So minority, in some books, you will see minority treated as an impediment by itself. Minority means not having the full capacity of execution. The period before adulthood, childhood, or not having complete capacity of execution, it is a matter of technical reference. You may either treat it as impediment because it doesn't have the capacity of execution, or treat it as a natural period that the person passes through to obtain the full capacity of execution. Well, insanity or junoon is an impediment. Junoon or insanity is an impediment which can affect legal capacity. If a person has junoon or insanity, deficiency of intellect from childhood, of course, he will be left with the capacity of assuming only, and he will never get, that is, as long as he has junoon, he will not get the capacity of execution, neither in the incomplete form nor in the complete form. But if a person becomes affected with insanity after having obtained the capacity of execution, meaning later in life, he is affected with insanity, he becomes insane, you see, now his capacity will be reduced. By reduced, we mean the capacity of execution will be totally removed. He will be left with the capacity of assuming only with its features. So junoon will result in the complete removal of the legal capacity, meaning capacity of execution. What is junoon? The definition for the purpose of is the Islamic law of transactions or contracts for junoon is that we define it as deficiency of intellect. Can you see the screen? Deficiency of intellect that causes an increased level of perplexion and agitation. Deficiency of intellect that causes an increased level of perplexion and agitation. This is not a medical definition. This is a feature-based definition for recognizing who is suffering from junoon of the level which can affect his contractual powers. So the person who is suffering from junoon, he's mentally unsound, and his deficiency of intellect is evident through his utterances and actions as well. The deficiency in his intellect is so severe that his bodily actions indicate that his intellect is deficient. He is prone to violence. He can harm people suddenly. So when the deficiency is of such a level that it is evident through his physical movements, it is categorized under junoon, which results in the removal of the capacity of execution. Well, so this has details. You can look at your reference material in the guidelines I have given. In addition to the basic material, you had referred to some additional material for additional details. So this level of deficiency of intellect is categorized under Junoon, that removes the capacity of execution, meaning he no longer remains mukallaf. He is no longer addressee of Sharia. Commands and prohibitions don't apply to him. Therefore, no criminal liability. You see, uh, so it has its effect on the capacity of execution as a whole, subject to details. Well, now there is a lower level of the capacity of where is the lower level of insanity that we call imbecility or ath. The higher level is junoon. The person suffering from junoon is majnoon, and the lower level is ath, and the person suffering from ath is ma'tu. This is also a deficiency of intellect, but this deficiency is not evident through his physical movements or actions. It is only evident through his speech. So we define this deficiency of intellect that we call ath as deficiency of intellect that is that causes or that affects his retention. Deficiency of intellect that affects his retention and expression. This is one way you can define this lower level of deficiency of intellect, which is evident through his speech only. His speech is mixed up. He may speak like a rational, sane person, and suddenly he can change track and speak like an insane person. So his speech is what gives away that his intelligence is not complete. But as far as his physical movements are concerned, he's not prone to violence. So he will not cause harm to people. And his physical movements are normal. So this level of deficiency of intellect, which can be identified through his speech, this is categorized under ath. Now, the effect of ath overall on the person is that it reduces the capacity of execution to the incomplete capacity of execution, meaning his capacity is similar to a mumayyiz child, discerning child, a child who attained discernment or tamiz. So we know that he has the capacity of assuming plus the incomplete capacity of execution. So this is his capacity with its resultant features. Well, now another factor impeding intelligence, impeding legal capacity can be unconsciousness. Unconsciousness. A person can become unconscious. So during the period he's unconscious, his legal capacity is altered. Okay? So we define unconsciousness as dysfunctioning of intellect. It is not deficiency of intellect. Dysfunctioning of intellect, you see, affecting cognition and intentional movement. Dysfunctioning of intellect affecting a person's cognition and intentional movement. Cognition means his sense of understanding. His five senses become affected. So while the person is unconscious, he cannot process information he receives through his five senses. He can't understand. And also he cannot move intentionally. He cannot move his body or limbs intentionally. So this is the definition of unconsciousness for our purpose, maybe for the purpose of recognizing the effect on legal capacity. So unconsciousness too removes the capacity of creating transactions and contracts, and his capacity is removed during the period he remains unconscious because his intelligence is no longer functioning during that period. Now, another impediment that comes close to unconsciousness is sleep. Sleep is an impediment. While the person is asleep, his legal capacity is affected or altered. If you, let's say, a sleepwalker creates contracts or does actions during his sleep, now they will not be given the same recognition as that of a person who is awake. So what is sleep? Sleep is very much similar to unconsciousness. As far as the outcome is concerned and external features are concerned, it is similar to unconsciousness, but only that sleep is natural, whereas unconsciousness is not natural. Unconsciousness is caused by due to some external reason, or it could be internal as well, but it is not part of the natural system of the human being. So sleep is part of the natural process. People become sleepy naturally. So if a person becomes sleepy, he need not feel alarmed that there is something wrong with him. It is entirely natural, for instance, to feel sleepy during lessons. This is not anything unnatural at all. You see? So you can become sleepy. So how do we define sleep? Yes, we define sleep as natural lethargy. Natural lethargy or natural languidness, you see, occurring periodically. Natural languidness occurring periodically. Unconsciousness not natural, and it does not occur periodically. Sleep natural and occurs periodically, which although does not remove intelligence, makes it dysfunctional. This natural languidness, inertia, the relaxation that overcomes his body at specific times, specific periods. This does not remove intelligence, but it makes intelligence dysfunctional. So this too is an impediment. So a person who is not able to create transactions and contracts in a valid manner while he's in a state of sleep. Well, so